Hello, and welcome back to Points and Authorities. This time it's for the week of the 19th of June in the year 2000. We are still, if you were paying attention last week, slogging our way through Volume 9, and we've got some important cases in Volume 9 that we're going to fill you in on. Starting with a case from Yuba County. We don't often get Yuba County down here, but when they get a case, it's a PIP and one you want to pay attention to. At page 1183, People versus Fountain. It's a sentencing case and affirms a 288A et al., but reverses the court's treatment of a juvenile prior, a 243D as a PC 667B parens-1 parens, reminding that particular court that prior juvenile incarcerations qualify as strikes only under very narrow conditions. It only applies if that prior, the one that we're basing the strike upon, is either listed in Welfare and Institutions Code 607B or is classed as a serious or violent crime under Penal Code 243D. Doesn't require proof now that the injury threatened is likely to occur, only that it did occur. In other words, we're dealing with an accomplished physical fact that we can use to nail down this kind of enhancement. And for that reason, ergo, as we say in the learned professions, 243D does not qualify under Welfare and Institutions 707B's kind of rigid admission policy here, so it is not considered a strike. And they cite People versus Garcia at 21 Cal 4th, that's the Supremes, of course, for that doctrine. That being the dispositive holding, of course, we here at Points and Authorities are a little puzzled that they give us all the graphic details of the rape of a 13-year-old victim, which really is not the issue here. The fact was accomplished. We didn't need to know that, but they seem to want to put it in the files, and that's the way the law is made. Moving down to San Diego, we have at 1238 Quezera, People versus Quezera, dealing with terms of probation, and this is another Wende kind of a flight of fancy where appellate counsel has to come up and do some creative things. In this case, the appellate counsel conjured three possible issues as possible, but not really arguable. The defendant was then in custody. He negotiated a plea of guilty to battery on a non-inmate over whom the opinion drops an impenetrable veil. We have no idea what was going on in their minds at that point, but inevitably they raise, of course, a Sixth Amendment ineffective of counsel argument. It's denied. He then argues the unconstitutionality of a plea, and that's denied. Whether the sentence imposed was consistent with the plea agreement. Well, it was. That was part of the negotiations that preceded even this report. And whether the probation terms were unreasonable. They were found to be so, and so they wind up by saying that his agreement, and this is again the negotiations that preceded the whole trial, to permit at any time a search of his or her person, car, house, et al., that is within judicial discretion. The court can impose it or not as the court sees fit. And 401 wraps this all up with a concise summary of the controlling cases on probation. That's one for your trial book. This is a good presentation on it, a lot of good citations, a lot of good material. The defendant asked to file his own brief on this and then declined to do so, so the rest of his consideration is beyond the ken of this decision, but it's a good, handy little opinion, particularly in terms of probation. The Spence case from Yolo County at 1242 reverses the suspended sentence of a probationer who is caught with a controlled substance and drug paraphernalia, and again, as in Quezera, a probation search, one of the conditions, holding the defendant had not agreed to, nor had the judge imposed, a search condition concerning to searches for drugs. What the judge had done in some anal retentive mood was to simply limit it to searches for stolen property. The Woodland Police Department relied entirely upon a computer-generated roster of probationers and the conditions appropriate to each, which had been compiled by the probation department. Well, it clashed with what the record of the court showed. Come to find out that the procedure came up with by the probation department there in Yolo had no procedure for recording limited search conditions. It was an all or nothing situation. Now, how do you handle that one? No question of the officer's good faith, at least no indication of it here. But there is a bit of a problem there for future reference, or at least for future anticipation. The idea basically is to make sure your officers, make sure anybody you're working with understands that it is not a one seizure fits all. It doesn't apply that way. Again, there's a problem with the opinion in that there's a lack of any discussion in this opinion why the police department shouldn't be permitted to rely upon the probation department's document. Probation department is an arm of the court. It's not a law enforcement agency, so the usual rules that would apply to not relying entirely on police-generated forms wouldn't apply here, but, I don't know, they may be late for lunch, it just doesn't come around. Evans versus Arizona, way back at 514 U.S. 1, 1995, said that police should have the benefit of good faith reliance on a somewhat similar situation, but that did not make the opinion. They apparently didn't have time to consider it. 1107, People versus Martin from Tulare County is a homicide, and the question here is the usefulness of voluntary intoxication as a defense. It affirms a 187 second for driving under the influence. The defendant tapped out at a .27 blood alcohol after inflicting an hour of terror on other motorists, injured 2 of them, killed a 4-year-old despite the 4-year-old being strapped into a child safety seat. Defendant appeals, of course, in his time focusing on instructions. He argues that CalJIC 4.20 was unfairly given in his case. Well, the court says it wasn't. It's from page 1112 on. They trace Penal Code 22 and they reject this defense drivel that it negates an otherwise worthy knowledge requirement for implied malice. Not required at all. Here they have another good summary. Good stuff coming out on this stuff. United States Supreme Court and California precedent otherwise. They take a look at the current state of California law and the legislative intent that this stuff be handled so as to deter further driving under the influence is unabated. That seems to go pretty smoothly.